I want to welcome you to the city of Duluth. We're pretty proud of what we're doing here, and I think if you haven't been here in a while, you're going to see a lot of changes in what we're doing here. We hope that you are going to have a good seminar here with us today and then enjoy some of our restaurants for lunchtime. But on behalf of our mayor, Nancy Harris, the city council, the staff here of the city, and the residents, we want to welcome you to Duluth this morning. I would be remiss if I didn't, as the co-chair this year of the overall Duluth Fall Festival, remind you that the 30th of September, 1st of October, we will have about 80,000 of our new best friends out here on the town green. So come see us and enjoy our Fall Festival. We have a nice parade that Saturday morning on the 30th, and nice service here. And if you're a runner, Sunday morning, the 1st of October, we'll have you out here for a Peachtree Qualifier 5K. With that, I'm going to turn it over to whoever is responsible here. Well rehearsed, you can tell.
Thank you very much, Kelly. We really appreciate the City of Duluth hosting us here today. Appreciate your hospitality. And I want to welcome you all here on behalf of GMA, and thank you very much for being here. We're going to give you an overview of some issues today that I'm sure a lot of you have been approached by small cell companies. So we're going to talk a little bit about that. Just to make sure everybody got a packet, you should have an agenda, a copy of our PowerPoint presentation, and a couple of model ordinances that we'll be going over in just a few minutes. Before we get started, my name is Becky Taylor, and I work on federal relations and research for GMA. We also have a few other staff members here with us today. Charlotte Davis is also going to be presenting in a few minutes. She's a member of our government relations team, so she works on telecom issues among a lot of other things. Tom Gale is also here in the back of the room. He's the director of our government relations team. And we also have Greg and Ryan Fender here. Greg's going to be giving our presentation later today after we have a quick legislative update. So now I will turn it over to Charlotte, and she's going to let you know kind of what's going on at the state legislature on telecom issues.
That'll work. All right, good morning, everyone. My name is Charlotte Davis. I'm one of GMA's lobbyists. I cover municipal government and also telecommunications, and I just want to thank you all so much for being at our workshop here this morning. We definitely think that this is an extremely relevant and important topic for our cities, and this is a really large discussion going on in our entire state right now. I can tell you that broadband and new technology is on the minds of our state house members. You probably have read a lot of headlines and heard a lot of discussion about rural broadband and how do we get, our underserved parts of the state more service, and then how do we build out this big 5G network and new technologies in metro areas. And just like that is a discussion going on at the state level, it's also a discussion going on across the entire country. I was actually at a conference last week in Boston, and it was a national conference for state legislators, and I went to the 5G and small cell antenna technology class, and there was a panelist there from the Federal Telecom Association. And she talked about this new technology that's coming, and she said that over the next 2 to 3 years, the telecoms think that they're going to need to deploy around 300,000 of these new small cells. And Greg's actually told me that's a fairly low estimate. So if you think about that, just how much new material and new infrastructure that would be coming into your rights of way to build out this new network, it's a monumental amount. And she said from the telecom perspective, the industry thinks that they need 3 key things to make that happen. She says they need greater right-of-way access, they need a uniformed, streamlined permitting process, and then they need a reduction of fees. And there's very much this attitude that local governments are the barrier. Local governments, you guys are the reasons that we don't have this technology. And she talked about 21 states that telecom legislation has been introduced in, and then states that the telecom industry sort of views as behind. And Georgia happened to be one of those behind states. And I can tell you, I certainly don't think that we're behind. Greg's going to talk a lot more about our program and everything that you guys are already doing. And we certainly don't think that that's a fair representation of our state by any means. But from the telecom perspective, we're sort of a thorn in their side because you guys still have access or are maintaining your rights away, and they don't have the access that they want yet. So just like that is going on, that narrative at the national level, they're using that same argument that Georgia is behind at the state house, and that the telecoms need legislation that's going to be in their favor, that's going to sway towards them so that we can get Georgia up to speed. So with that, I do want to talk about 3 bills briefly that were introduced this past session. And you can see how it does sort of have the assumption that local governments are behind, and we need to reduce those fees and get into their communities to get out this technology. The first bill I want to talk about, this is House Bill 518. This was a bill that was brought by a company named Crown Castle. And Crown Castle is a little bit different of a telecom. They actually are what's considered a carrier's carrier. So they don't have retail in-use customers like you and I. They're not going to send us a phone bill. They're not providing any local direct service, but they have wholesale customers like an AT&T or Verizon that they can boost services for. So this bill does recognize that if you're a company with 3% or with retail in-use customers, then you're responsible for paying 3% gross revenues. That's fine. Current law, telecoms are already doing that. But it sets out two additional categories that if you don't have retail in-use customers, but you have wholesale customers, then you're still responsible for 3%. That's fine. We're good with that. But one additional category, or if you don't fall under one of those two, you then are responsible for paying a $500 linear mile fee. And the thing that's so significant about that is it's a huge reduction of current fees. The current Georgia state or GDOT state law would require $5,000 in an urban area and then $1,000 in a rural area. So this bill would seek to reduce just every linear mile would be a $500 flat fee. So you think that's saying that the same linear miles in a Duluth or a more urban area have the same value as rural miles. So this really was kind of a silly bill, honestly. The rest of the telecoms didn't really like it either, just because why should Crown Castle or a company with that business model get a reduction if they don't get to enjoy the same? So just, it is good to know though that this bill is out there, that sort of company exists. The next bill I do want to talk about is Senate Bill 232, and this was a much larger bill, a much more comprehensive bill. This was introduced by Senate Majority Whip Steve Gooch, and this was completely backed by AT&T. It's sort of their industry-written bill, and this, like I was saying about rural broadband, is their approach, their solution. It's the Fiber Act, facilitating internet and broadband rural expansion. So this is how we get rural broadband, and really after going through the bill, there's not too much that ensures that there would be any build out in rural Georgia. It'd be more just a reduction of fees and easier access into the metro areas. One significant section of this bill that we're watching and that we're definitely aware of is Section 2, and that's really what cuts out so much of the local control. That's pretty much an outright preemption of municipal control of rights-of-way. And it does this preemption in several ways. It talks about multiple different areas, about reduction of fees and costs that you'd actually be able to charge for right-of-way usage. So of course, nothing that's unreasonable or discriminatory, but when you think of unreasonable for this new technology, a lot of times it's hard to figure out what a proper fee for it is, and really what's reasonable for an AT&T might not be reasonable compensation for a municipality. And then it actually sets caps the fee $20 per pole, or makes it subject to an FCC rate. And Greg's sort of explained to me how complicated the FCC formula is, but it pretty much will reduce fees to around $5 to $6 per pole, which is even lower than $20. So that's a lot less money coming back to our municipalities, and that makes us uneasy. And then it also talks a lot about permitting. It would assume that when a municipality receives an application, you pretty much have to grant it as deemed. You'd have to accept it as reasonable and go ahead with that site request from the telecom. And there wouldn't be much you could do as far as defending against, hey, that might not be the best site, or that's against a zoning ordinance, or that doesn't go along with the aesthetic character of our community. And then once the permit was actually granted to the telecoms, the permit would not have an expiration date, and they would be able to be in control of when they pulled that permit, especially within the first year. So we kind of think that if you think about it as us as retail customers to some of these companies, we can't terminate our contract with them just any time in the first year without any penalties or fees. So this would really give them a lot of authority that would be coming away from the current authority that we have on maintaining our rights of way. So again, this is a really large bill, but it didn't go anywhere last session. It was just introduced. We are talking to Senator Gooch about it. We're in meetings with the industry, and this is sort of their ideal bill. If they could get everything that they wanted, they threw everything in, but knowing that they would have to make, significant compromises to really get a good piece of legislation, if we even need one at all. And then this next bill, just real quick, this is actually introduced on the House side, but it's also an AT&T bill, and really had much of the exact same language from 232. It's just a shorter, more condensed bill, but again, it goes back to local governments are the barrier to getting technology into our communities. This would seek to give unregulated right-of-way access, supersedes a lot of permitting and zoning current laws and current authorities that y'all have. And then it would eliminate the ability for you to call a moratorium. So a lot of times these telecoms come into your community and they have, applications for 30 different sites and they expect you to turn those around in 10 or so days. This would prevent you from being able to call a moratorium if you needed more time to really look at those, look through the contracts, look through the applications, see what they were trying to propose. And again, that sort of goes back to very much this hastiness. They just want to come into the community, start digging, sort of give you a nod or a hi and go about their business. So I know that that's sort of daunting. There might not be a lot in there that's good for cities, but I will say I think that the best thing is really having our membership engaged on this issue, having these workshops, having you guys know about these issues. It is technical, it's tricky, it's a new technology. A lot of the telecoms really don't even know as much about this, what these small cell antennas are going to look like any more than we do. So like I said, we're working with the industry, we're working with the legislators, we're working with our counterparts at the county. And these are going to be continual conversations, and we're going to be calling upon y'all to reach out to your legislators and to let them know really why it is so important for you to continue maintaining control of your rights of way, and really that y'all know your communities better than the legislator, better than the federal level. So with that, if y'all have any questions about state legislation, I'll be happy to take them. Yes, sir.
The one question on
Sure.
the bottom highlight talks about commence within a year. So apparently there's some definition of commence. You want to talk about that?
Yeah, so the way that was written, it actually is that it's sort of vague, and I think purposely to be in the favor of the telecoms, but once the permit would be granted from the local government, they could have any point in time in the first year to just begin work, and then within actually 2 years, they'd have any point in time in 2 years to begin actual construction of structures or facilities. So again, it gives them a lot of leeway in when they actually start work, and still if they can pull and set up shop, we don't like this community as much as we thought, we're getting out of here. So it's purposely written vaguely so that they can have more flexibility. Yes, sir.
So I think everybody fundamentally agrees that the small cell technology to support the 5G broadband is necessary as we grow our economy and we all
Sure.
support the growth of mobility. But I don't blame the AT&T lobbyists or Crown lobbyists or anybody else for drafting legislation like this. But what it seems to me that there's a balanced view between doing nothing and just letting an unregulated system and letting AT&T get their way.
Sure.
Is GMA coming up with a more balanced piece of legislation instead of just trying to fight HB 33 or the
Sure.
Senate version?
Yeah, so that's a great question, and I do want to make the point that no community in Georgia, I feel confident in speaking for y'all, does not want this technology. No community wants to rely on broadband or just be completely in the dark. We want this technology. We want to be on the cutting edge. We want smart cities, but we don't necessarily think that legislation is the way to get there. I mean, Greg's going to talk a lot more about our program, but we've made a lot of steps in good faith to work with the industry that haven't required legislation. We have a model right-of-way agreement. We have a model permitting ordinance. So I think that's sort of the balanced approach, in that it doesn't need a one-size-fits-all piece of legislation from industry or really from us.
So let me see if I understood your answer. You are working to develop a more moderate piece of legislation from GMA or not?
No, we're not. Right now we don't have, I think our approach would be additional language working on this bill. I mean, 232 is our largest bill. So I think our goal legislatively would be to put our own language into that bill and hopefully get a compromise. Introducing another bill might become, a target, or, oh, that's a local government bill. So I think working on a compromise legislatively with what's already out there would be our best approach.
Does GMA have a good relationship with Senator Gooch?
We do, yeah, we definitely do. And he's been very responsive, and he understands, this is AT&T driven, and when it was introduced, we had not had any input into it, neither had ACCG, so we will continue talking to him, but he knows that it's a work in progress and wants to, he's been very responsive to us. He's come to he was actually at our convention and talked on our panel, so he knows our concerns and he'll continue to hear them.
Okay, thank you.
Sure, thank you for your question. Great, well, thank you all so much. Yes, sir.
Does any of the legislation contemplate relocation and reimbursement and reimbursable expenses associated with relocation?
It really just addresses co-location, and then if co-location can't occur, then there would be relocation or, I guess, locating of new additional poles. The industry, for what it's worth, has said they are trying to get away from large 125-foot poles and really trying to co-locate antennas as much as possible. But if it is in there, if it's put in, it'll probably be in favor, for them. Great. Well, thank y'all. At this time, I'd like to call on Becky. She's going to give us the FCC federal update.
Thanks, Charlotte. I appreciate that. I'm going to give you the update from a federal regulatory standpoint. The FCC has been doing their best to work with the industry to figure out how they can keep local governments from being a barrier to deploying broadband, because that is sort of the industry's perspective, is that we're the number one thing standing in the way from getting their equipment out and from providing the service, just like Charlotte said. Earlier this year, a couple months ago, the FCC put out a proposed rule that would address these types of issues. And basically it was asking the questions, how can we get local governments to be more cooperative with the industry, or how could we get them kind of out of the way so that we can do what we want to do? The first thing that they looked at is the shot clock requirement. Let me see if I can do this. There we go. The FCC would basically want to look at the shot clock and see if it should be shortened. If it was, and then if permits were not approved within that certain time, then the permits would be deemed granted. So the city officials would not be able to take any action on that, and the company would be able to proceed. The other issue that they dealt with is, maybe the FCC should be responsible for setting guidelines for aesthetics. And I don't know, if you can imagine how terrible that would be. The difference between the way that the community is in the city of Savannah, the city of Helen, and Atlanta is totally different. You create the atmosphere that you want to have in your cities based on what your citizens want and based on public feedback. The FCC has no business regulating those sorts of things. And then they also did look at the compensation issue and whether fees were arbitrary or whether they were too high, and maybe they should look at reducing those fees. The thing they didn't do was really look at what barriers the industry itself poses to broadband deployment. A lot of times we'll get industry bringing in a packet of permits to a small city, and it's a very technical thing, and cities can't get through it right away, and then they'll review the permits and send it back to the industry, and they'll be the holdup. They won't get the corrected information back. So as many times, we've heard this all over the state, and Greg can talk about this a little bit more, about companies who don't respond to city requests for additional information. So they're actually the holdup. And what we've been trying to do is make comments, both formal comments and meetings with FCC staff and with one of the commissioners, to point out the local government side of it. Basically, they have no understanding of what local government does. They don't really understand what the public right-of-way is or why you need to have any control over it. But our position is that this is something that we have a responsibility for, both in terms of public safety and also your fiduciary responsibility. The Georgia Constitution actually requires you to charge something to these companies to be able to locate in the public rights-of-way because of the gratuities clause. So they weren't aware of that. They didn't know. We were sharing this information. It was the first time that they had heard it about what cities have to do. So we feel like we're at least presenting a little bit of the local government side. We're working very closely with the National League of Cities, and they've done a terrific job of trying to bring city officials in from all over the country to talk about what they do on these issues. So we're very hopeful that they'll listen to our side. Another thing that I'll mention is that Chairman Pai, the FCC chairman, created a group called the Broadband Deployment Advisory Council, the BDAC, and its responsibility is to come up with recommendations for ways that we can compromise and work together on deploying rural broadband. One of the groups within that, one of the subcommittees, is assigned to come up with model local regulations, a model ordinance. We're very fortunate in Georgia to have a representative on that group. It's Larry Hansen. He's a city manager in Valdosta, and he has worked tirelessly on this committee to come up with recommendations that will help protect cities' interests. He's also working very closely with another subgroup, which is dealing with a model state ordinance, so that we can make sure everybody's kind of on the same page and all of our public rights-of-way are protected, and that local governments have authority over those. So we're continuing to work on that. So far, no action has been taken on the rulemaking. Earlier this year, there was also a petition by the company Mobility on behalf of small cell companies to look at similar issues, and no action has been taken on that as well. And what we've asked the FCC is just to hold off on doing any kind of rulemaking until their BDAC has time to come up with recommendations. They created that group, and we want them to respect the time that they've put in, make sure that they consider those recommendations that they come up with. That group is set to have their recommendations ready in early November, so we're just going to keep an eye on this and continue to work with the FCC, continue to work with NLC and our other partners at the national level and other state leagues, and we'll just keep you posted and let you know kind of what's going on at that level. Are there any questions? Okay, if not, I'll turn it over to Greg.
Well, it's a great pleasure for me to be here this morning. I'm Greg Fender, and my son Ryan Fender, who some of you may have talked with. We are the technical arm of GMA, and we have the pleasure of working with Becky and Charlotte and Tom and other GMA staff, but particularly with them on legislative matters, and they call on us as needed. And so we've got a lot of ground to cover today, and we're going to talk about a little bit about small cell antennas companies. We're going to talk about the legislation we just went over and how that relates from a technical standpoint to services here in Georgia, and talk about some areas where I hope that you can walk out of this room and be able to take home and generate additional revenue for your city. And I'd like to begin, I've been working with GMA since 1986, and it starts to sound like it really impacts to know that I'm getting older and older when you think about 1986. But it's been an absolute pleasure and to be associated with such an organization. And but you know, we started a telecom right-of-way management program, which is known as today. We started in 1993 on behalf of cities, and it basically was born because of federal law changed at that time. Actually, it was passed in 1992 to establish the right for cities to be able to regulate cable TV rates. And so we formed a program where cities would pay an annual retainer to participate in that program, and it would enable GMA to hire the expertise to help you and spread that cost over a broad base to regulate cable TV rates. We had cities like LaGrange, though, who came forward and said, we want more than just assistance with regulating rates. We want assistance with negotiating pole attachment agreements. We want assistance in negotiating cable franchises, and also to be able to do audits to determine if we're paid correctly. So from that, the program grew to what it is today, and it's now changed to, rather than just cable and telecom, but the telecom and right-of-way management. So it's a much broader program. But I do remember in the mid-90s where AT&T asked me to come to their kind of a laboratory they had set up in Chamblee, and it was a simulated like living room. They had put you in a nice leather recliner and have you like in this living room to watch their new version of television. And so they had a movie on, and at that time, now again, remember this is like 1995, 1994, had a movie on, and they said, Greg, would you like to stop the movie and go get some popcorn or whatever? And so it was neat to stop the movie, and they said, oh, you missed a scene, you want to see it again? And we would rewind the movie, fast forwarded it, and this was all coming off TV, and they had various menus for us to be able to choose movies, choose whatever we want, set the time of when we wanted it. And I came back to the GMA that afternoon. Should have went home, but went back to GMA's office, and so came back and just telling everybody in the office building, I've seen the future, of television, and this is absolutely fascinating. Of course, we all know that today, and you have all that. It's common in our homes. So to me, it kind of relates to today. about small cell antennas. It's like all of a sudden, hey, this is a new technology, and initially it doesn't seem to be that grand, but it's what's coming behind it that's what's so fascinating. It is. You see these large cell towers, we have them everywhere, and if anyone thinks that small cell antennas are going to replace these tall towers, that's not going to happen. These small cell antennas are simply the ability to come into, say, like downtown Duluth, and the gentleman, the council member, was talking about the 80,000 that would be on the town green here at the end of September. That is a perfect application for small cell antennas. You're going to have a large congregation of people, and it's hard to get the capacity or the bandwidth from those large towers to that many people without this having drop calls or not being able to download things or send messages and things like that. So the small cell antennas that will actually boost that signal, boomeranging off those towers. And so consequently, that's why the initial small cell antennas have been placed around the major point of where they want to install them is the new Brave Stadium, the new football Falcon Stadium, all your university football stadiums, anywhere again where you have a large congregation of people. And then downtown areas, large pedestrian areas, large residential areas where it's hard to get these large towers in. So it'll be so much better to have those small cell antennas. And that's great. And I live in Dahlonega. I work out of Dahlonega. And we're starting to see, I don't know if you're experiencing it, but drop calls we're seeing is more difficult to have internet services off our wireless phones. And that, again, that even in a small town like Dahlonega with a university, with North Georgia there, I believe it's all due to lack of capacity. So we're going to have more, small cell antennas wanting to come in and more towers. And so to help with that capacity. Now, and the small cell antennas is not directly related so much to improving your voice calls over the phone. It's more directed towards helping with data and video. Netflix is a huge component of people downloading movies, streaming movies off their wireless devices. And with more people doing that and more concentration of people, it's difficult to have those applications work if you don't have the capacity. So the small cell initially is going to be focused on that, but you're going to hear more and more of this phrase used, the Internet of Things. And this is what's exciting about the future of this technology. Elon Musk recently was talking about in a speech that in 10 years, 50% of the automobiles in the United States are going to be electric. And then he says in 20 years, to see an automobile with a steering wheel would be like the equivalent of you seeing a horse and buggy out on the interstate. 20 years, he's saying that we will not have cars with steering wheels. It'll basically be a car, a laptop on 4 wheels. Now that technology exists today, and it's in, just as I talked about being in a laboratory and then Shamley, Georgia, looking at this newfangled TV back in the mid-90s. People are sitting in rooms and out on test roads doing this right now. And these cars and this technology, whether it's, there's a commercial on television you'll probably see, it's starting to run more of a older gentleman watching his grandson play basketball in the gymnasium. He's a farmer, and he has on his smartphone, he's programming it, he's dialing in to turn on his sprinkler systems on his crops. And he's doing that remotely from the gymnasium, where you're going to be able to use this technology to even monitor whether there's enough cash that needs to be replenished in an ATM machine or whether it's a Coke machine, whatever. So that's the exciting thing about this technology. And I believe we have our top leadership at the congressional or federal level and our state level that have actually been exposed to this technology and has been able to see that. It's kind of like Moses going to the promised land, they reveal it to you. So it's like you're able to, as a leader, get insight to what that technology is going to do. And so basically it's like they come back and say, we've got to make sure we remove any impediment or anything that's going to slow down the deployment of this technology. So then we have a new administration come in, and we have Chairman Pai. He's a new chairman. We have new leadership at the federal level. And basically, Chairman Pai, he was a former attorney, I believe, with Verizon. And so one of the first sweeping reviews they're doing is at the federal level is to look at local governments in all facets of how they regulate the right-of-way. And the industry sees a great opportunity here. Not only and they're covering their bets both at the state and the federal level to be able to push legislation in various states and also at the federal level with the FCC to look at trying to streamline their ability to use your right-of-way and almost to the point if they'd like to be able to just ride in the town, start just with a wave and start excavating and doing the work in your right-of-way and also pay you very little for the use of it. That's in summary about the gist of how it sounds. And but no, we are working towards trying to have some modifications to the legislation. We do have a good relationship with Senator Gooch. I live in, like I said, Dahlonega. He's a neighbor of mine, and we know each other, and of course he knows the GMA staff really well. And so we're looking forward to continuing to have a dialogue with him and other representatives to hopefully protect local government's interest in this area. It does, for someone that's worked in this business for so long, it is a difficult pill to swallow when you hear someone at the state level say that Georgia cities are an impediment or a barrier to deployment of broadband services. I think we need to push back. Everyone needs to, when you hear that, either at the local level with your state representative, if you hear that, and we as well need to be able to challenge people when you hear that kind of statement and say, which city are you talking about? I mean, are you talking about the city of Duluth, Lawrenceville, Alpharetta, Johns Creek? I mean, which city out there do you know that is actually stopping these companies from coming in and providing these services? I just can't imagine, since 1993, since we've been in this business, I have never known of a company coming to us saying, we're not going to this town because of the fees they charge or because they're just too difficult to work with. We just haven't heard that. And so, I think it's easier for them to paint cities with a broad brush and in the abstract to be able to say cities are slowing us down, cities are deployment. But then you stop and ask them, which one? Who are you talking about? Because GMA would be glad to call that city up and see how can we assist them in getting through this roadblock to get this going. They've never said a word. They've not said one city that we know of, and not named one, and I don't think they've called you, have they? And so we're still waiting to hear who the problems are. But that is, and the other thing is, when we're talking about deployment of broadband services, the way, if you look at the history of broadband deployment in our country, the FCC recently, in 2016, in one of their reports, listed the cable industry as the greatest provider of broadband services in our country, and as an industry. And if you think about it, when we talk about fees, first of all, in Georgia, our fees are capped at the on cable at 5% of gross revenue. That's federal law. State law caps basically 3% on telecom for retail end-use services, and then on wholesale services, you cannot exceed whatever the Georgia GDOT charges for the use of state right-of-way. So our fees are set. So to try to act as if our cities have the latitude to just set nilly-willy fees all over the waterfront. That's just not correct. And AT&T needs to be challenged on that. And now we do have, some cities have a little bit more flexibility on small cell wireless, and we're going to go a little bit more into that about what GMA has done to try to help counter some of these arguments. But the industry is made, and particularly AT&T. But if you, going back to cable, since 1984, federal law has been that cities can charge up to 5% of a cable operator's gross revenue. That's not a cost-based formula, that is a market-based formula. And again, 5%, so for every dollar they generate in your town, they're paying you a nickel. And so those fees certainly have not been an impediment to that industry being able to grow. That industry has grown to the point now where they're providing, telephone services. They also provide the broadband internet services, and which is more than anyone else. So our argument would be those fees, which are much higher than what we're even talking about in the small cell antenna world, they have not been an impediment to deployment of broadband services. And now, with all that said, I think it comes across that where we stand in terms of the legislation, we're not supportive of it. We will be glad to try to work with them on it. Now, Charlotte made a comment about the industry looks at Georgia as being behind. At first, I didn't know what that meant when I first heard that, but I take pride in that now, saying that, with the 21 states where they've introduced legislation and they've got some of these passed, and they're looking at GMA or Georgia as being somewhat more, I guess, difficult to get that legislation passed through. That's a credit to GMA and to you. Because, when you look at it from a streamlined standpoint, GMA in 2008 developed a model right-of-way ordinance, right-of-way permit ordinance, which basically provides a kind of a uniform approach for cities to, for companies to be able to come to a city, say, what is your right-of-way permit ordinance requirement? Here it is, and here's what they have to do to submit their application for a permit, and here's the consequences if you don't. I mean, if you don't seek a permit from the city before you start digging or before you start deploying your services, there's penalties associated with that. So and it was interesting when we first started hearing rumblings and applications from numerous cities about mobility trying to come in. We actually received a call from lawyers with American Tower, and their comment to me was, it sounds like what's going on down in Georgia is like it's the old West, just wide open, just people getting to come into the right of way and do whatever they want. And I said, I don't know who you've been talking to, but I said, that is not the case. And I said, here's what we have in Georgia. We have the GMA model right-of-way permit ordinance that a lot of cities have in place. They follow that, and here's how we're, here's the draft of what we're working on. Here's what we have, and as the pattern after the GDOT master right-of-way agreement. And after he saw that, he came back and he said, do you mind if we present this to other states as a model? And he said this is one of the best right-of-way ordinance we've seen, permit ordinances we've seen. And I haven't heard much more from American Tower. I think they realize that Georgia has its act together, and it's not the Wild Wild West as he first heard. And but I think it'd be good now for me to talk a little bit about the history of, well, before I talk about the history of where we are with mobility, the other step is we have the master right-of-way permit ordinance, which does help streamline their application process. But secondly, GMA, as I just mentioned, has this program, a technical services arm program in place since 1993, almost a quarter of a century, that cities can call on for technical assistance or call any questions to get assistance on any questions that come up. And Georgia should be really, should be clapped on the back on that and congratulated, because we do this work, our company does this work for 5 other municipal leagues. We work and have for over a decade worked with Texas, Arkansas, Mississippi, Alabama, and South Carolina. But all those programs are endorsement type programs, and there's not a program where cities and counties have been in it for 25 years straight and have the ability to call any day on any subject that's hitting the right of way and get assistance. And that's management. That's management and being proactive and not reactive like we have in other states. So you can go from here to California. You're not going to see another state have this type of program, and the industry knows this. And the only other place you can see this type of program is in Northeast United States, like Massachusetts, New Jersey, New York, and I think that's the only thing we have here in Georgia that we have in common with those people in the Northeast. But on a history of how we became involved with mobility, is Tom Roser here with Berkeley Lake? Tom, he was ground zero with mobility. And Ryan and I received a call from Tom almost 2 years ago saying, we got this company calling on us. And we were like scrambling to say, what, 125-foot poles? What's going on here? So it wasn't long after that we had conversations with mobility. They told us about, educated us on small cell antennas, what they were doing. And we were pleased to hear them say, we said, our cities, what we're hearing initially is they do not want a proliferation of poles, new poles in the right-of-way. And they certainly don't want a 125-foot pole in the downtown area. And what they told us then was, well, we have a contract now with Georgia Power to co-locate on their poles. And so we thought, well, hallelujah, that's great. Now this is going to be easy. All we've got to do is work out an agreement that addresses compensation and, of course, all the normal provisions like insurance, indemnification, and some processes like that, and we should be off and running. Well, they just went silent after that. We went about 6 months not hearing too much from them, and then all of a sudden we just started getting inundated from cities. There's 153 cities in this program and counties, and we started hearing from all of them. No matter what size or how small, they were calling us saying, we've got applications from Mobility, a company called Mobility. Most people would call it Mobilite, and but it's pronounced Mobility. And saying every application was the same. They wanted a 125-foot pole, steel pole, in the city's right-of-way, and again in the downtown area. In Dahlonega, if you are familiar with Dahlonega, you probably know the Smith House, where a family-style restaurant that's been there for, oh gosh, I don't know how many years, but a lot of people like to go to the Smith House. Well, that's where they wanted to put their 125-foot pole, right in front of the Smith House. And of course, we would have been run out of town and or escorted out of town if we'd have said, oh yeah, that's a great place. But so we had cities everywhere, and they were all saying to us, we do not want any pole of this type in our downtowns. And it was never ever about compensation. I don't recall us ever having a conversation with the city about what type of revenue compensation opportunities do you have with this. It was more of the city saying, we just do not want this type of infrastructure in our downtown. Now, a lot of the cities were being hit with, at that time, letters, somewhat threatening letters from them saying, we are certificated by the Public Service Commission of Georgia. We're a communication local exchange carrier, and we have utility status. And we want to come into your right-of-way, install this pole under our utility status rights, and we don't want to pay you a dime. And it was like, get out of the way, city. You got 15 days to approve this, and we're ready to go. So that's what we were receiving, and we were receiving that kind of response from cities, upset, saying, what can we do to stop it? Well, working through our outside legal counsel, which is a fantastic part of this program, is Brian Grogan with Moss & Barnett. I urge you to Google Brian and learn more about him, but he's a tremendous asset to our program. and nationally known. And basically looked at Georgia law, looked at, we are very fortunate that, again, they could revert back to the GMA model right-of-way ordinance, that it adopts by reference the GDOT accommodations policy manual for how companies can locate in the state right-of-way. And because the cities and because GMA had this ordinance that adopted that by reference, the GDOT manual basically said that they were not going to allow, they do not allow any installation of new poles in the state right-of-way. And they encourage and require these companies to co-locate on existing utility poles. So that was basically our ability to push back, to say, and they received letters from all of these 153 governments in uniform saying they're not going to allow this because of X. And that brought them to the table. And so last July we started working with them, and GDOT has a master right-of-way agreement that they use with these small cell companies. We utilize that to adopt one that would be for local governments. The differences between the two are this. The GDOT agreement basically is again, emphasizes co-location. It does not allow installation of new poles. And then for compensation, they charge $900 per site. And when I say per site, that means if they go up on a Georgia Power pole in the state's right-of-way, they will pay the state $900 for each site. And that's 52 feet around the circumference around that pole. That $900 allows them to use that 52 feet. The Georgia Power pole mobility would have to pay them and have to enter into a pole attachment agreement with them, and they would have to pay them a pole attachment fee to rent space on their pole. And that pole is in the state's right-of-way, so that's why you have to pay, that's why mobility has to pay the state for the use of that right-of-way. The state then, there again, has no provision at this time or since then, for the installation of a new pole. So there was no fees, of course, associated with that. And then they had a 25-year permit, and there was no option to readjust the rent during that 25-year period. We certainly understood GDOT's position about not wanting companies to install new poles in the state right-of-way, because if you think about it, state right-of-way, you've got highways that have a much higher speed than, say, a typical city street. And so from a standpoint of traffic, they didn't want to have, it would add more danger for their workers and for others and for people working on poles if they're out there with cars driving by at 60 and 70 miles an hour. And that's one reason they prohibit that. So in cities, we looked at it that, okay, we do have some lower speeds on some of our streets. We have some ability, more flexibility in the state. So we basically said to mobility, we want to, first and foremost, require you, just like the state, to co-locate on existing utility poles. If for some reason you cannot, and you got to document why not, why you cannot co-locate on an existing utility pole, then the city will consider allowing you to install a new pole. It won't be a 120-foot pole, 125-foot pole. It will, and then the second part of our agreement, which is very, very strong, it basically says if you're going to install a pole, then it's going to be a pole of the city's choosing. It'll be a design of what the city's design would agree, what you'll agree to as a design, where it's located, and the actual wording says they will utilize stealth technology. So we want the pole to be disguised as much as possible, not to look like a pole. And so I mean, we'll have a pole with a little larger diameter so they can put all their equipment, all their wires inside the pole, and then the antenna at the top. And in a lot of cases, and I think there was a slide we've had up here where the pole looks like a street light. And we've had 8 permits awarded in Augusta. Almost every one of those are generally like a security light or an ornamental street light. And then at a minimum, their poles have to resemble what all the other poles look like in the area. It cannot stick out like a sore thumb. And the height of the pole contemplates it not, with the antenna, not being more than 50 foot in height. If they try, you know, we still have some rural areas where they persist with taller pole. We had met with the city manager yesterday from Donaldsonville down in southwest Georgia, and they are putting in, I think it's a 75-foot pole. But when they come in with something over 50 feet, then all bets are off on the compensation. We then, instead of it being, I didn't even talk about our compensation yet, but it in Donaldsonville now it's $2,500. And our compensation that we set in the agreement, has it compared to the state's model. You remember that I said the state's was $900 to co-locate on an existing pole. To incentivize them to co-locate on an existing utility pole, we said $500 for Georgia cities. And then again, we had the flexibility to allow them to install a pole, and where the state's rigid in saying no poles. If they install a new pole, then we had it set where they would pay $1,350 for the new pole, plus a 3% annual inflation rate, and if someone co-located on their pole, they'd have to pay an additional $500 a year on that pole. And then also, we set it where the permit was for 10 years, and at the end of 10 years, you get to renegotiate the rent rate. Whereas in the Georgia state model, they have a 25-year permit, that's it. There's no option to renegotiate. Then finally, one piece I think is important. This is the same company, as Becky said, filed a petition at the FCC with a new chairman to say, please look at how local governments regulate the right-of-way, and they wanted to look at how they wanted to ask the FCC, the federal government, to look at possibly preempting local rules and regulations to allow them to have faster deployment of these services in the right-of-way. So the nice thing was, after negotiating this, and after they had filed that with the FCC, you know, the FCC asked local governments for comments on this potential rulemaking. And so GMA were negotiating with Mobility, struck this deal. Mobility signed the agreement with GMA in January. And so when GMA filed its comments with the FCC, we were able to attach to those comments and tell the FCC, the company that filed the petition with you has just now signed an agreement with us in Georgia on how they've agreed to the compensation, and they've agreed to how to access the right-of-way in Georgia. And so basically, in essence, we're saying to the FCC, we've shown you how cities can work with these companies, and we're basically asking the FCC, leave us alone. We can do this. And it still strikes me as interesting from the first place that we could even have to me it's ludicrous, to even have any legislation like this proposed, because if you look at it over a century, cities have been regulating the right-of-way. I mean, you have regulated and worked with Georgia Power for over 100 years. You've worked with Atlanta Gas Light for over 100 years. You've worked with the telephone industry as well for 100 years, and the cable industry for 50 years or so. So, I mean, we have a track record, a good track record of working with companies. And so just because this is a newfangled technology, I don't think you need to throw all that out. And we've certainly shown with Mobility we can work with them. Now, the other companies that we're working with in Georgia on small cell antennas is Crown Castle. Some of you may have heard from Crown Castle. Crown Castle and Mobility have two totally different business models. Mobility is all about erecting a pole or either going up on a pole and having a line of sight technology like a microwave technology where that's how they're providing their services and boosting that signal off these high poles or high cellular towers. And they primarily work for T-Mobile. I'm sorry, they primarily work for Sprint, and then some for T-Mobile. Verizon, not Verizon, but Crown Castle, they run long fiber runs. They're not so much putting up poles. They can utilize a lot of existing poles. They occasionally have to put up a new pole, but they're doing long fiber runs. Now, under the state law, if you do a long fiber run and you get beyond that 52 feet, and I'm just going to use this example because we're all urban cities here, and it's in urban cities, it is 5,000 per mile. That's what the GDOT rate is. That's what your rate would be. So if Crown Castle's coming in, that's what they would be looking at paying. Now, they're asking for modifications on that. We're trying to work with them. We'd like to be able to go to the legislature and say, we're also able to work with this company. Athens is close to getting something done. And with them that we may be able to start using as a model in other areas. We're encouraged by that. Verizon's been working with the city of Savannah. They've entered into an agreement with the city of Savannah as early as early 2015. They've been paying, they've got something like 30 plus sites in Savannah, and for each one of those sites they pay the city of Savannah $1,200 for each small cell facility. There's a 3% annual escalator on that, so it's probably close to what we have now, of $1,350 per site. And they are also coming into Columbus right now. So again, and then finally we got AT&T, who we've not had the pleasure of working with at all in our 153 governments that are in the program, and they range all over the state and a lot of small towns and rural areas. And again, AT&T is telling the legislature that you enact this type of legislation and it's going to enable us to go into rural Georgia. And the only place we've seen AT&T is the city of Atlanta, and we just learned they're in Cobb County with the new Brave Stadium with their small cell antenna. So we haven't seen them in Parent, Georgia, or Omega, or Tai, or any of those communities. and it kind of reminds me in 2008, after they had passed legislation in Texas, 2005, 2006 in the Carolinas, they basically eliminated local franchising, and they basically told these legislatures that if you will allow us, like in Texas, to just have one state franchise and enable us not to have to negotiate with 1,200 cities in Texas, we'll be able to come in and provide competitive cable TV services, wired cable TV services, to all the cities in Texas. Well, they said the same thing to Georgia in 2008 when they asked to have one state franchise instead of having to negotiate with you real difficult people, and on an individual basis. And the Georgia legislature provided them that. And so now, again, if you ask cities in South Georgia, did they see AT&T with wired line services, or in North Georgia? I'm talking about way on up, like Livonia or Blue Ridge or someplace like that. No, we never saw AT&T make it. Now they've abandoned that now, and they've bought DirecTV, and so the push now is going to have them migrate people off the wired AT&T UVerse product, and so that will free up more bandwidth for their internet service, and they'll have people going to DirecTV for video. And so, you know, I think the legislature has to be reminded about that history, and when they basically hold out the possibility that we're going to, you do this for us, and then, and we've mentioned to Senator Gooch and other senators that one problem we have with the legislation, particularly when they want to eliminate all the fees that cities can charge for the use of the right-of-way for these small cell antennas. I mean, we, as I pointed out to you, we have cities already that have working documents, working models that where the cities are receiving compensation, and it would be, in our opinion, terrible for cities like Alpharetta, Norcross, Johns Creek, Duluth, where you've got tons of companies wanting to use your right-of-way, as you know, and for you to be able to have to give up your fees with the possibility of a promise of serving rural Georgia. And I'm like, you know, why would the urban cities give that up? Well, I think it's pretty evident That just goes to AT&T's bottom line. And so that's a problem we have. We got to work through this. And but anyway, that is a kind of a summary overview of small cell, the importance of small cell, what GMA's doing right now with the industry, how we're working with them. One other piece that I cut off the subject on that master right-of-way agreement with mobility. I got off the subject by saying that they were the ones, mobility, the ones that filed that petition with the FCC. Well, one nice thing that mobility we have in that master right-of-way agreement that I want to call to your attention, if the FCC passes legislation that preempts what we can do, or if the state legislature passes a bill that again preempts what we can do, then mobility is saying that they will agree to the contract or the permit for the 10 years and pay you the compensation that's in the agreement until 10 years, even though legislation was passed to preempt it. So, and that's for all permits that happens before that preemption. Anything after that, of course, would be preempted. But I think that's an important element of it, and we certainly wanted to include that in negotiations when we knew they were the company that had filed it with the FCC. The next area I want to talk about, which is now we get into, yes, sir.
Let me make just a quick comment.
Sure.
In the room on small cells. I'm Jim Wright-Dycher. I'm a council member at Dunwoody, and we're maybe a little further down the road than a lot of you. I think from a city councilman's perspective, get on it now, get an ordinance in place so that you can control permitting, control this work coming in, because what brought it to us was, all of a sudden we had these small cells popping up, and they were, an antenna on the top of a pole, a couple of boxes, and a rat's nest of wiring that looked like, well, it looked very bad. And so, and we had no ability to regulate it until we had an ordinance in place. So get on it, get ahead of the game, just for that reason alone. The money is not that big of a deal to us. Yes, we charge some poll fees, and I couldn't even tell you how much money we're taking in on that. It's down in the noise fundamentally. The reason to do this is aesthetics and get some control over aesthetics, because the industry is getting better, but back when this was happening, they were very much behind the curve. My counterpart, Lynn Deutsch, and I attended a Technology Association of Georgia session on small cells about a year ago as all of this was happening. And let me tell you, at that point, the industry was, it's very much in a rapid state of change. They weren't caring much about aesthetics. It was a room full of engineers, and I am a Georgia Tech grad, so I understand the mentality. But the bottom line is, we definitely made them know that, they needed to pay attention to aesthetics, and the way to make these companies pay attention to aesthetics is get your ordinances in place, get your regulations in place, and get your community development and public works folks regulating that when these guys come to town. So that's my 2 cents worth from the city council perspective.
Did you draft that ordinance yourself, or your city attorney drafted it themselves?
We did with help from GMA. So you can, if you go to Muni Code, you can see our ordinance.
So is it still the one that was handed out this morning?
Well, we're not. I don't know. I think we're a little. I think there's probably a lot of overlap.
Okay.
But there's probably stuff in ours that's not in GMA and vice versa.
Yeah.
It's worth taking a look at as a reference when your city attorney gets into it.
Well, thank you for those comments, and those are important comments. One I didn't mention was, this technology, again, as I said before, particularly with the Internet of Things being in the laboratory type, but small cell antennas has been in place now in our country in numerous large cities for some time. Like if you go to San Francisco, it's been there for some time, Minneapolis, Las Vegas. If you go down the boulevard in Las Vegas, the internet services you're receiving, or wireless service you're receiving off your phone, is from mobility off their system there in Vegas. So again, we want to get this moving. I think it'll be so much more helpful to Charlotte when she's at the Capitol to be able to say to the legislature, we already have numerous cities working in this area, and we don't need this type of legislation. Yes, sir.
Greg, how many cities have actually adopted it?
You know, we haven't kept up a really good count on that, but my guess is probably closer to 20 now that have adopted this. And that's another good question. I want to make sure, there's so much to cover here, but the one thing I want to make sure you understand, we look at this as like the Texas two-step dance. You know, it's a two-step process. It's a two-step. One, we recommend that you adopt the master right-of-way agreement with mobility. It doesn't mean just because you adopt that agreement that they automatically can start coming in and installing things. All the agreement does is set the parameters of what you are agreeing to as far as compensation and a process about how they will make an application to you to install their equipment. You're much better off to have that agreement because that agreement says we want you to co-locate. And if you can't co-locate, you got to tell us why you can't. And then you govern how that pole is designed and where it's put, and it goes back to your aesthetic comments that you're in control of. And so I just want to make sure you understand, just because you adopt the master right-of-way agreement, that doesn't mean you look out your window and see their truck and they're putting things up. That's just not the case. Okay, I'm going to move on to fiber. This is where I think cities, I want to make sure that you are picking up all of the revenue that you're entitled to here. We had, in Georgia law, since the 2008 Telecom Act, as I mentioned before, cities can only charge for 3% on retail end-use service. That's like your old telephone service. And that is a legacy, like AT&T is a legacy provider. That pre-existed 2008. Anything, and since then, I mean, nothing's changed. They just keep paying the 3% on a quarterly basis. But for all these companies that are running fiber through your town, there's some that just literally come through your town to get to another point. You've got cell towers around here that you see in Duluth. What you're going to have is companies, and I know Teresa, we've dealt with Tower Cloud. Tower Cloud, you got Level 3 Communications, you got Zayo. You got these companies who are running fiber to various places, large industry, or in the case of a tower, they're running fiber to a tower to upgrade that to a 4G or 5G network. And so with that dark haul fiber, they in Duluth or some other community, they should be paying you $5,000 a mile to utilize your right-of-way. And they are providing what's called wholesale service. So you're not going to get like Mobility as a carrier's carrier, or Verizon with a small cell, or Crown Castle. You and I will never receive a bill from them as retail customers. Their customers are the wireless companies, and they're providing the infrastructure for them and charging them for that. But they are running their infrastructure in your right-of-way, and they should be paying you. We have a large number of these companies that have not paid cities. We had this presentation Monday in Livonia. The little town of Bowman's mayor called me yesterday morning and said, Greg, you know, I told you about a gas company that ran fiber through our town and with their gas line. And she said, I've learned they sold that fiber to a company called Level 3 Communications. Have you ever heard of them? I said, all the time. You know, they owe Tucker, City of Tucker money, which I think I've just deleted the email. Got a email late yesterday afternoon from the finance director of the City of Tucker saying Level 3's paid. And so Ryan will be contacting Level 3 on Monday to say, hey, we need you to pay Bowman, because she told me they've never been paid. And so we had this going on all the time. So my recommendation to you is when you leave here, go back to your offices, look at the last 4 or 5 years of who you have permitted to work in the right-of-way. Compare that, do a cross-check with your finance department to see, have you been paid by all those companies? And if you've got any inkling that you've had anywhere in the notes in the file saying a company's name, but you don't even see where they've ever paid you, let us know. We can help you go back and collect that money. And some of you newly formed cities, that probably would be an area that could be ripe for you. And now I'm going to go into the next area is water tank tower leases and tower land leases. Yes, ma'am.
Before we jump into that, with the fiber, so we're fairly not new, but we're smaller, but we're getting hit by a lot of companies asking, do we have a permitting process?
Which city?
City of Dahlonega.
Okay.
And so what are our steps? Like, how do we move forward?
Well, you want to, and we can get with you after this, but we want to get you going first with the GMA model right-of-way permit ordinance and look at what you have now. If you don't have something in place, we need to get that in place. And that'll be a number one starting point. And then we need to look at which companies are calling on you. Okay? And because each one may have a little different, one's a wireless company, one's maybe a wired company, and we need to be, you have to approach them differently. Okay, water tank tower leases and land leases. Look, quick.
There's a question over here.
Yeah, I can save it or I can ask now, but my question is, when you do have a fiber company, are there any that are also looking to do these small cell technologies? And if so, what do they fall under? Do they fall under the Telecommunications Act? Or how does that work?
That's a good question. We look at it with the small cell wireless company they do come in and say we're following 4518, but we contend that bill was written for wireline companies, okay? And small cell are different, so we look at them as having to enter into an agreement, a separate agreement to utilize the right-of-way, okay? And yes, sir.
One more question. We had a company come in probably 3 years ago and ran fiber optics down the railroad.
Yeah, okay. Yeah.
Line. Does that still count?
No, sir.
Okay.
That's railroad right-of-way. And I don't think there's anyone more powerful than a railroad than God. And yeah. Yes. So I learned a long time ago, early in my public service career, not to mess with the railroad. But but anyway, water tower leases. Let me tell you this little thing that's just happened. I think it illustrates, the point well for us. City of Savannah has a water tank tower right off of I-95, and it's located right at the airport of Savannah Hilton Head Airport. And we had a company, large telecom company, have come to them wanting to install, I think it was 12 antennas on their water tank tower, and they offered the city $18,000 to utilize their water tank tower. Now you'll probably see in this slide where we have as a general rule for even the most rural site in Georgia, we recommend that you don't take anything less than $24,000, okay? That's a minimum. And so here they are coming to Savannah offering $18,000. And then you got to assume this large telecom company knows that the city of Savannah has got a city attorney, got a city manager, got a bukus of other staff members that can help, probably a lot more, even more staff attorneys they can help. And they're also, if they looked at the GMA website, they would see Savannah's been in the program for 24 years, and they're going to get help here too. So I don't know if they all thought we were asleep at the switch, but they offered $18,000, and so we already had our pre-meeting with the city staff, and they said, yes, Greg, you have free license to say what you want on the conference call. And they're on the call, and I told them, the site locator, I said, we're just a little off on the compensation, and I said, you guys may want to, your client may want to go somewhere else on I-95 and get another piece of property, because this may be too much for you. And they said, well, how far are we off? And I said, $50,000. $50,000 a year. I said, the city wants $72,000. You offered $18,000. And they were like, was there any play in that number? And we said, no, there's no play in it. And 3 days later, they called and said their client has agreed to the $72,000, and just that quick. And so the Savannah should be signing that agreement, should be signed here early in September. The phone's been burning up about when they can get on the agenda. And so my point with that story is when you look at one of our largest cities getting that type of proposal, what do you think they're offering our other cities in Georgia when they come to you for a water tank tower lease or a land lease? I can tell you, always make the assumption that they're lowballing you big time. And what we've generally find with water tank tower leases now, they can easily run anywhere from $3,000 to $4,000 is common. And so my recommendation is when you get one of these proposals, before you even talk money, go back on your computer, and one of the first things we do is go find the address of this water tank tower that we're talking about, and pull back and look on Google Maps or whatever, look at a satellite view of that water tank tower. Zoom in and see what is around that water tank tower. And generally you're going to find interstate highway, or you're going to find a state road that's heavily traveled. I mean, you know, we're not far from Peachtree Industrial here, tremendously traveled road. You've got, and Sugarloaf Parkway, you've got, these things have like a 2 mile or longer circumference of where they're reaching. And depending on the height of the tower, it could be even more. And so you may also see a lot of residential areas, a university, or a mall. So that begins to where you can talk with them intelligently about what you think that rent could be. And if you have some data, you can start really pushing that up. And they generally come in, they want to talk about a 25-year lease. It's a 5-year initial term with 4 automatic 5-year renewals. I would recommend as a negotiating employee that you kick back and say, we're willing to do 5-year initial term, or either 1 initial 4-year term with 2 automatic 4-year renewal terms. So you're really talking about 12 years versus 25. They're going to kick back on that, and they're going to say, oh no, we just have to have that 25. Well, then you use that as their negotiating employee. So we might could give you more term if we can get that rent where we want it. And then you'll see them to start trying to boost that. Always make sure that you have the ability, though, that you had final design approval about what goes up on that tower. And they should pay you for whatever the engineering costs you have as far as out-of-pocket costs. Any consultant that you use to help you with the tower, they should also pay for that out-of-pocket cost. Your response on something like that is we're a city. This is not our normal expertise. This is not our normal, we're not deluged with people coming to us wanting to use these facilities. So when we do periodically receive something like that, we go outside to seek outside expertise. And they should not argue with that. And so they will reimburse you for that cost. They will also generally have in their document a 3%, no, they will have an inflation escalator clause. If it's silent on that, you definitely have to raise that issue. You should have an annual escalator. We've seen some communities where there's been some water tank tower leases with no escalator, and it's just a set fee for a long, long time. And what they will typically do is say, we'll kick in 10% after 5 years. Every 5-year term we'll do 10%. Well, that is equivalent of like 2% per year. So what you want to do is say, no, we're not going to set that. We want 3% annually on the anniversary date. Every year it goes up 3%. If inflation starts bumping up, you know, we have some cities doing 4%. That's very unique, but in the old days it used to be 5%, but it's been a long time, I guess you know, since 2008 that we've had any real inflation. And so they would be sensitive to anything above 3% at this time. The other thing is you want to make sure that you have in the agreement, get as an exhibit, like a picture of what equipment they're going to initially install in your tank. Have an itemized list of a number of antennas and the type of equipment that will be up on that water tank tower. And you basically say in the agreement that for any modifications to that initial equipment, they have to come back to you for your prior written approval for any changes. It gives you an opportunity to renegotiate the rent. And we've talked a lot about earlier in the program about 4G networks, 5G networks. They're going to have to all upgrade these water tank towers, these antennas on the water tank towers. So it gives you an opportunity to be able to adjust the rent as they want to use more of a public facility. Now think about that. If you were trying to go to AT&T and you were renting space on one of their towers or poles, and you came back to them and said, well, the city's now going to need more space. Well, I guarantee you they would hit you for more money if you're using more space on their facility. So the same goes for cities. Should charge more for the use of the public facility. I mean, and you know, one thing I also failed to say, you know, one of the responsibilities of a city on managing the right-of-way or these facilities is, one, the elected officials are the elected trustees of that right-of-way. And their primary role as a trustee of managing these facilities is that, one, that the public's compensated for its use. I think we've had some other sessions where people have mentioned that there's a gratuities clause in the Constitution, that cities cannot allow companies just to use the public right-of-way or facilities for free, because that would be looked upon as a gratuity to a private company. Secondly, you're overseeing that as a trustee to make sure the right-of-way is, or these facilities are not damaged, they're not disrupted, and that they're placed back in their original state when they leave or when they're using them. And thirdly, you're the regulator. You're regulating who uses those facilities, and you make sure they're not interfering with another private company that's using the facility, or for the public and the public safety, that is not interfering with your ability to provide services to your community. And again, that's why it's so important that these companies are not successful at the state level or the federal level to usurp these basic rights of local governments that have been in place for over centuries. And that's so important. Back on the logistics or the provisions of a water tank tower, one other thing you want to, you know, we focus so much on money, but just as equally as important is how that water tank tower is used. The water tank tower is generally, it's got to be painted periodically. It's going to rust or whatever. You've got sometimes routine maintenance you have to do on that water tank. And so these companies have to know that when that happens, they got to move their equipment. There should be an orderly process for them to move their equipment within a timely manner, and they should move it at their cost, not your cost. And we typically, I'll make you aware if you get a proposal for use of your water tank tower from Verizon. Verizon's probably the biggest player we see in Georgia and in the Southeast as far as investing more capital in this infrastructure, much more than AT&T. Right now, Verizon in the last several years has been the big player. But they put in their model agreement, and every one of them, they have as a standard language that if the city requires them to move their equipment, that you will pay for the removal of that equipment. They don't highlight that for you. They hope that you sign this agreement and have that provision in there, intact. And believe me, if they're doing this for 30,000 governments and they got half of them to have that provision in it, they're looking at it from a national standpoint. They're looking at it from a national standpoint of a national company. They just save themselves a ton of money. And they will stick you, and they will adhere to the provisions of that agreement. We just had a city in South Carolina, Lake City, South Carolina. It just was a nightmare for them because there was no provision in the agreement that governed this. And they had a paint contractor, long story short, that got so frustrated because they kept coming out to the site after the company was told that they had to move their equipment, and they kept delaying and delaying. The paint contractor finally adjusted the contract and said, "City, you're going to owe us $60,000 for their failure to do all this, and it cost us more money to keep having crews on standby and things like that." So then the city had to get legally involved with the company, and the company agreed to reimburse the city for those costs. But it just goes to show you, if you have a good agreement that's drafted, drafted for the city, that will help you down the road. If it's, generally you don't have to refer to these agreements very much. They sit in a file or whatever. And but when you do need them, and you have to revert to those agreements, refer to them. Those govern how you both react to the issues. That's a contract. And from that, I also want to mention with the water tank towers, it's kind of dovetails into, every now and then we have these companies we hear that will approach you and say, if you hire us, we will go out and market your water tank tower. We'll go out and market any land you own to these telecom companies and ask them to let them know that you've got a water tank tower, and they can come back and put their antennas up on your place, and we'll negotiate the agreement. In exchange for doing that for you, we want 30% of your revenue for the next 25 years. That is I bring that up to your attention because we do have some cities that have done that. And to my belief, it's terrible public policy. It's not good use of a city's money, and it is exorbitant. If you think about it, every city, is pretty common knowledge that every city you can reasonably assume owns a water tank tower, and you also have some available land, and so these companies like Ryan and I, when we're negotiating with Verizon, AT&T, US Cellular, whoever, we never negotiate directly with those companies. They have site locators that they hire to go out and obtain a site, and they use say Verizon's model, legal lease, or AT&T's, and we redline those things or whatever, kick them back to the site locator, and all the site locator does is send that to AT&T legal, and ask, and say in Verizon's case they use Troutman Sanders here in Georgia. Just goes to Troutman Sanders. We've got to know these people on a first name basis, and they kick it back. And they usually now set to all our red lines. It's become a somewhat common, but they'll kick it back. But my point is, you've got a site locator coming in that has been hired by these companies to go out and find a site. They don't need, and what they have their charge is, the company's saying to them, from a heat map, we're showing that we're dropping all kind of calls in this area, or our service is not good here. We need stronger signals and better service here. So they know they've got to get that area served. And so it's a bonanza if they walk in and see, hey, there's a city water tank tower, or the city has some property there, we can build a tower on it. And because one, if they prefer to work with you, because if they can work with the city, they don't have to worry about zoning. They're working with you on city property. Two, if you do not have property that they can use, then they're going to have to see you anyway, because they got to go on some private landowner's property, and then they have to talk to you about zoning aspects. And so that's why I'm saying you don't need some go-between marketer when that all is happening. And so, and particularly when you have to pay them 30% of your revenue over 25 years. That basically is almost like, in a lot of cases, equivalent anywhere ranging from $200,000 to $400,000. Those people will be paid over a period of time. That could be the city's money. A land lease, this is important. I hope you remember this when you leave here. The land lease is, if you look at this tower right behind City Hall, when you walk out of City Hall, if you walk this way, look to the right, that's a perfect example. You'll see this large 250-foot tower with several arrays of antennas, just several. And it's common now to see that off of any interstate. When you're driving home, you'll see these large number of arrays of antennas. Fortunately, Duluth has in their agreement, not only do you get a base rent, a monthly base rent, but remember they're going to lowball you on that rent. But generally, you want the good base rent, but in addition to that, you want at least anywhere from 20 to 40% of the company's revenue, rent revenue, they're receiving off that tower. And when they present these agreements to you, they're never going to present to you a provision, a document that contains revenue share. You'll have to bring it up to them. And a lot of times when we bring it up to a company or one of these site locators, they may say to us, that's a deal killer. And we always respond, you're absolutely right. It is a deal killer. If you do not have that provision in this agreement, it's dead. And we're not going to recommend it to the city. So magically, after they say it was a deal killer, they usually come back and say, okay, we'll agree to a certain revenue share. So you want to make sure it has that in there. We just show you a little thing about how valuable that can be. Little town of Raymond, Mississippi, right outside of Jackson. It's had for years in their water and sewer lagoon. American Tower owns a tower out there, and they have numerous companies on that tower. But those companies, they're charging anyone to go up on their tower anywhere from $3,000 to $5,000 a month. So if you're getting 40% of that revenue, that's going to far exceed your base rent. But that little town receives $70,000 a year off of that tower. And it's mainly because they have a 20% revenue share component in it. I think the highest we know of in our program, Smyrna has a 50%. And so we try our best to get that, 30, 40% and hit higher if we can. But that little town, to show you how valuable that is, they've been offered, I think there's still about 11 years left on the lease. American Towers made them 3 offers to buy out their lease. They started at $400,000. The last offer was $1.2 million. And each time the little town of 2,200 people has turned them down. They realize they can do the math. They know they're better off having the rent revenue. That gives me a segue into one other thing. If you have leases now, you will probably understand that you're getting calls all the time from companies wanting to buy out your lease, some kind of way to get their way into your lease agreement. I have not seen one of those that ever be in the city's interest. And so I would advise you not to entertain those. You'll also have some companies calling saying, we'll give you $15,000 if you sign this just to extend the lease term out. And they're saying like 20, 30 years. And there's a lot of that. And again, those are, we had Hattiesburg, Mississippi a year ago. Company offered them $5,000 to extend the lease. Long story short, we got them to say, okay, now $40,000, but increase the revenue share up to 30%. And so it behooves the city to extend the lease, particularly if they can get 30%, because the longer the lease, you're going to have more companies wanting to co-locate on the tower. So now the city can benefit from that. And plus get $40,000 as opposed to $5,000 just by doing it. And most of these we just do not see are in the city's interest. And then we have this lovely crowd that usually works for AT&T, and it's called 2 companies out of San Diego, one called MD7, the other's called Black Dot Wireless. You may receive a call from these gentlemen. And now you'll recall I mentioned about there's a lot of companies out there that always want to pay a small amount of money to extend these leases out 30 years. They're showing you they want to have these leases as long as they can. But here comes this crowd with a different story. And they call you up to intimidate you, and they say, mergers, because due to mergers and acquisitions, small cell antennas, AT&T may just leave your tower, and we may just leave, unless you agree to reduce your rent. And if you agree to reduce your rent, then AT&T will consider staying. And then if you bite on that and agree, okay, we sure don't want to lose this, but we'll agree to this reduction, then they take the liberty to come in with their draft amendment, and that draft amendment says not only did you reduce the rent, but they usually take out the annual escalator clause, and then they also say that for the next 25 years, if they want to add any piece of equipment to your property, they have pure license to do so without asking you for your approval. And that's a disaster. So we generally, when we talk to these guys, and you have to remember, we work with them on a daily basis or ever so often. Their calls to us have tippered off, but generally we got where we would just tell them, oh, you're calling the city about that we'll say, look, we'll meet you out there at the property and help you. We'll have some boxes and help AT&T move their equipment so y'all can go on down the road. And but the city's not reducing its rent. And I can tell you, we've never had them once leave a city's property, so it's a bluff. City of Statesboro, 2 water tank towers 2 years ago. This same company, MD7, called and said, we have, same thing. They said, in this case, they said, small cells antennas are coming, and we may, AT&T may leave. Well, we happened to see where the lease agreements were going to expire in 2 years. There were 2 different water tank towers. So it was 2017 is when they would expire. And so we said to them, not only do we reject, they wanted to go from 30, the city was receiving $36,000 per tower. They wanted to drop it down to 33. And so, and of course extend the lease a long time. So we said, not only do we reject your offer, we raise it. We want 48,000, not the 33 that you want. And long story short, after about 9 months of negotiations and them having to reimburse the city for the cost of the GMA program, they agreed to $45,250. That $45,250 is actually due today for one of those water tank towers. And the reason we called them the other day is the other one was due June 9th and they hadn't paid it. And so right before I walked in this room, AT&T was on the phone going, oh, you know, lordy, we missed the payment. We'll get that taken care of. So that happens all the time. So I just want to make sure you get those type of proposals. Those are the kind of things you just want to either refer them to us or just tell them, no, we're not interested, period. Finally, I think it was just a summary of our program. Again, I've already mentioned the GMA program. One thing I didn't mention as part of that is if you have not done an audit of your cable operator in the last 3 years, we highly recommend that you do so. And since 2012, for example, during that period, cities doing audits of various cable companies in Georgia has recovered over $2 million. And you know, it's not just recovering the money, it's correcting it going forward. Give a quick example, we had Comcast along the eastern coast, all the coastal communities. They were not including franchise fees on late fees they charge customers. And City of Savannah, being as large as it is, it had only that one source of revenue where they had not paid that. And so going back 3 years, the City of Savannah picked up $150,000. But more importantly, now that's corrected. So going forward, each year going forward, the city is receiving $50,000 more dollars a year. That gets you easy about what, close to 1.5 police cars full, you know, a year. So even for a city like Savannah, you're getting close to 15 police cars out of that over a 10-year period. So that's what we're talking about. If you get this revenue turned around, you can use that for city services without having to, it maybe lessens your reliance on property taxes, but it maximizes the revenue that's being used by private companies that are using your facilities in your right-of-way. And with that, that concludes my comments. I'll be glad to try to answer any questions. And again, thank you for your service, your public service to cities here in Georgia.
Please help me back there.
As far as
Mobility?
mobility
Yeah.
goes, they have not approached our city. Are you suggesting that we reach out to them specifically
No, sir.
to have an agreement, or are you just wait?
Just
until they
wait.
approach?
Just wait. Which city are you with?
Swanee.
Oh, they're going to approach it.
Yeah, that's.
They definitely will approach Swanee. I'm surprised they haven't.
Yeah.
Ryan? No?
I can follow up with them.
Maybe they don't know where Swanee is.
I mean, I'm just curious.
Mm-hmm.
I guess the second question, I think I know the answer to it, but it's kind of a technical question. Local governments generally are not supposed to sign agreements that go beyond 1 year without automatic renewals. And a lot of the terms that you were talking about were, you know, extended terms. Does that issue come up?
Yeah, it does come up, and You know, our attorney's paid like $3.90 an hour, so I generally don't go to him on this because it's been so commonplace. In Georgia, and GMA's legal counsel could answer this, but you do have the rights, local governments have the right to contract for long terms on companies that are utilizing your right-of-way. You know, like Georgia Power, your Georgia Power contract's 40, 50 years. Atlanta Gas Light, the same. Cable companies, generally 10 years. And now you've got, in the cases in Georgia, you got all the companies with the exception of Comcast that are providing cable. They've all gone under a state-issued franchise. Comcast is about half of their cities they chose to be local franchise, half state franchise. But no, you can bind one council with another for these type of contracts.
So I'm from Dunwoody as well, and the first place I guess it was Crown Castle, chose to install small cell sites was in my neighborhood.
Okay.
2 houses down. And it was a train wreck.
Mm.
They would start and stop and start and stop. They wouldn't finish. They left the wires
Yeah.
out at the base.
Which violates your electrical safety standards, yeah.
Yeah, everything.
Yeah.
And on top of that, I would come home from a meeting or something, and they would still be working in someone's yard at 8 o'clock at night.
Mm-hmm.
And so I haven't read the model ordinance, but I just want to make sure for those of you that have like restrictions on work hours and stuff, it's probably in here maybe. But make sure that if you're interested in protecting your homeowners, that you address all that. And on top of that, we have rules in our permitting process about when construction can be done that impacts our traffic flow. And so in our case, it's usually 9 to 4, sometimes 4:30 in the summertime. And so think about all that, because just yesterday they were doing some kind of cabling, AT&T, and they backed up traffic on one of our main thoroughfares for 2 miles at school dismissal time.
You've raised so many important points there, and that I realized that we didn't even address. Right. But one, that goes right back, and that's a great example about how it's so difficult to have a cookie cutter approach that the industry wants to propose for cities, because what's important to you and in your community is totally different maybe in another community, or more workable in another community. I mean, that's like comparing Savannah and a historic district with the city of Atlanta, and it's just not the same. And there's different interests there. I did want to bring up in the right-of-way agreement we have that it is a model, and with all models, you over time you modify them. Even since we began the model in January, we've had it tweaked 2 or 3 times. Augusta, I think someone asked before about legislation to Becky about relocation. In the master right-of-way agreement, Augusta, with the help of Augusta, we added a section in there about relocation, basically, and it also is in the GMA master right-of-way permit ordinance on relocation. But basically, if you have to change the design of your street, the scope of your street, close the street, whatever, and you got to have them move their infrastructure, they got to move it at their cost, and they got to follow the city lead on that.
Can I ask a follow-up?
Yeah.
So these things are ugly, at least the ones they started with.
And they shouldn't be. They shouldn't be.
They're still the ones they started with are cylinders, and some of our utility poles aren't very quite visible. But I'm a little concerned that the technology is going to evolve and to abandon this technology for something else. Does your model agreement talk about removal?
I believe it does talk about removal, but I just, not off the top of my head, I'd have to look at it, but I think it does. And again, if it doesn't, it will probably be picked up in the right-of-way permit ordinance. I think I was reading it just the other night to help me get to sleep. It was, I did read where I think there's provisions in there that they have to remove everything that was in the right-of-way. Okay, is there anything else? Okay, Becky, you want this microphone? Thank you.
Thank you, Greg. Every time I've I've heard this presentation 5 times this week, and every single time I learned something from Greg. He and Ryan just have a tremendous amount of experience in this area. It's a really complicated, technical, and rapidly changing area that we're all dealing with. It's good to have someone with this type of expertise that you can turn to. But whether or not you use our program, whatever you decide to do when you're approached by these companies, please don't sign anything. Even if you're not a member of the program, give us a call. It doesn't cost anything to call us and just ask us to take a look and make sure that you are getting what you're entitled to, that you're protected in the use of your local authority to regulate the rights of way. I think that when, some companies, I think like Mobility started out looking across the country at where they could start approaching local governments and try to get what they wanted. They started with the South, feeling that maybe they could just, we would be a pushover. But they have learned very quickly that we are not. We have done a great job of working with Mobility, and we hope to work with other companies to come up with similar agreements. It does help us with our advocacy efforts, but hopefully it will also bring a balance to your community to be able to get the technology that you want while protecting your local interests. So that's hopefully you've learned a lot that you can take home today and put in place in your own communities. I want to say again how much we appreciate the City of Duluth, Teresa and Kelly, and everybody here from the city. We really appreciate the opportunity to come to this beautiful City Hall. Thank you for your hospitality, and I hope you all have a great afternoon.